The most expensive word in estate planning isn't taxes or legal fees, it's later. After 30 years in this field, I've seen that we avoid uncomfortable conversations today only to leave a burden on our families tomorrow. It doesn't have to be that way. I'm Jim from ELM Legal Services, and today I want to share with you the biggest lessons and practical advice that 3 decades of experience has taught me. The first lesson I've learned is that most estate planning problems actually begin with good intentions. People say things like, my family know what I want, or everything's going to go to my spouse, or the kids are going to sort it out between themselves. I've dealt with many estates where there was no will, just verbal promises made over many years. Everyone believed something different had been promised. The result was years of tension and legal costs that could have been avoided with a clear document. Good intentions need structure. Without it, they often create confusion rather than clarity. A properly drafted will turns good intentions into clear instructions and removes the burden of uncertainty from your family. A will is essential. Without one, the intestacy rules apply, and they rarely reflect what people expect. But even a well-drafted will has limits. For example, a will only takes effect after someone's passing. It does not allow someone to manage your finances if you lose capacity. It does not give authority over health or care decisions. It does not explain how money should be used for someone who needs support. And it does not control how assets are managed long term. That is why the strongest plans look beyond the will alone. While the will remains the foundation, it works best when supported by lasting powers of attorney for decision making during life, sensible asset ownership, a clear letter of wishes, and, where appropriate, trust and inheritance tax planning. The law might be clear, but families are rarely straightforward. Over time, relationships change. Expectations form and assumptions quietly build. Blended families, second marriages, children from previous relationships, or uneven financial support during life all increase the risk of problems later, even when there is a will in place. I've seen perfectly valid wills challenged, not because they were wrong in law, but because people were shocked by what they found and had no context or explanation for the decisions behind it. The lesson I learned: clear conversations during life, backed up by written explanations where appropriate, often do far more to prevent disputes than silence ever does. Inheritance tax is one of the areas of estate planning where timing and accuracy absolutely matter most. Many people assume it is something that can be dealt with later, perhaps with a quick change towards the end. In practice, that rarely works. Most effective inheritance tax planning depends on decisions being made early enough for them to take effect. Steps such as lifetime gifting, using available exemptions and reliefs, and putting trusts in place can be very effective, but only when they form part of a clear strategy and are carried out correctly. The rules are very detailed, and small mistakes can undo the intended benefit or create new problems. For that reason, professional advice is strongly recommended when dealing with inheritance tax. The right guidance helps ensure the rules are applied properly and that planning is reviewed and adjusted over time, rather than relying on assumptions or those last-minute fixes. When a beneficiary is vulnerable, estate planning needs extra care. That vulnerability might be due to age, disability, mental health, addiction, or difficulty managing money. Over the years, I've seen situations where leaving an inheritance outright created serious problems. Funds were mismanaged, lost to outside influence, or placed pressure on someone who was not in a position to handle it. Careful planning can reduce those risks. Using appropriate structures such as trusts, tailored provisions in a will, and a clear letter of wishes can help ensure support is provided in a controlled and protective way, and used in the beneficiary's best interests. The practical lesson is that vulnerable beneficiaries should be considered very early and planned for deliberately. Taking the time to put the right protections in place with professional guidance where needed can make a lasting difference to their security and well-being. People often assume will disputes are driven by greed. In my experience, they are far more often driven by misunderstanding. Families are left asking the same questions. Why did things change? Why was someone treated differently? Why did no one explain what was meant to happen? When there is no context, people fill in the gaps themselves. And that's where suspicion and resentment grow. Even perfectly valid decisions can feel unfair if they come as a shock. Clear records, professional advice, and written explanations do not guarantee there will never be a dispute, but they do make challenges far harder to pursue and give executors something solid to rely on when questions are raised. Most disputes are not about the money itself. They're about the story people think the money tells. One misconception I've seen time and time again is the idea that estate planning is something you do once and then you forget about it. In practice, life rarely stands still. Relationships change, families grow or blend, assets are acquired or sold, and the law itself evolves over time. I have often come across arrangements that made absolute perfect sense when they were first put into place, but no longer reflect the person's wishes years later. In some cases, failing to review a will after a major life event such as a marriage can even affect whether it remains valid at all. What tends to work best is treating estate planning as something to revisit from time to time. Rather than constantly rewriting everything, a sensible approach is to review your arrangements every few years, and always after a major life event such as a marriage, birth or death, or a significant change in your finances. Estate planning works best as an ongoing process, checked and adjusted when needed, rather than something that's done once and then forgotten. The final thing I want to highlight is also the most common mistake I've seen over 30 years in estate planning. It is the quiet decision to keep putting estate planning off until tomorrow. It's easy to assume there will always be time to deal with it later, or that it's not something that needs attention right now. But the reality is that life is unpredictable, and plans that keep getting delayed often end up never being made at all. Putting things off can leave families facing uncertainty and added pressure at the very time they are least able to deal with it. Planning early gives you control and clarity, and makes sure the people you care about most are supported with clear guidance to rely on when it matters. The best time to start is usually now, while decisions can be made calmly and on your own terms. At ELM Legal Services, we're focused on helping individuals and families across England and Wales put plans in place that reflect real lives, real relationships, and real responsibilities. If this video has prompted you to start planning or to question whether your current arrangements still do what you expect them to do, a short conversation with a professional you trust can often bring more clarity than months of putting it off. If you do choose to speak with us here at ELM, we offer a free initial meeting, giving you the space to ask questions and see whether it feels right before making any financial commitment. If you have found this video helpful, please like, subscribe and share it with someone who might benefit. Remember, a little planning today can make a big difference tomorrow. So, until next time then, stay safe, stay informed and stay tuned.